January 27, 2026. What was supposed to be a routine procedural hearing walked into a federal courtroom and came out unrecognizable. Not because of violence. Not because of chaos. But because the system revealed its reflex. This was the day Mahazano, also known to the world as Nnamdi Kanu, appeared on a court docket for a simple request, relocation from Sokoto, citing safety and detention conditions. Nothing radical. Nothing dramatic. Just procedure. And yet, from the very first moments, something felt wrong. This was never about relocation. This was about control. Nigeria has learned to recognize the feeling. The quiet tightening of the room. The sense that an outcome has already been decided before anyone speaks. The betrayal does not announce itself loudly. It arrives dressed as normalcy. People were told this was administrative. Technical. Boring, even. But Nigerians know better than to trust boredom when power is involved. Because the most dangerous decisions are often the ones no one expects to matter. And by the time the hearing ended, it was clear something had been neutralized without ever being debated. That is how systems avoid accountability. They do not fight arguments. They collapse procedures. This was not justice derailed by force. It was justice redirected by design. And once you understand that, anger is no longer emotional. It becomes logical. Because nothing here justified what followed. Which forces the next question: if the request was lawful, reasonable, and humane, why was it treated like a threat? Strip away the politics and the fear. What remained before the court was painfully simple. A detainee requested relocation due to safety and detention conditions. This is not extraordinary. Courts hear such requests regularly. The law recognizes them. Procedure allows them. Humanity demands them. There was no legal wildfire here. No justification for panic. No reason for sabotage. Nothing here justified what followed. Because what was put on trial was not emotion. It was a person. In Nigeria's justice system, procedure is often used to pretend neutrality. But neutrality collapses the moment procedure is weaponized. When the system stops asking whether something is reasonable and starts asking whether it is convenient, injustice enters quietly. Mahazano's absence from court was not unusual. Detainees are often not physically present for procedural motions. But when absence collides with sudden instability in representation, the imbalance becomes glaring. A process that should have protected dignity instead exposed vulnerability. And vulnerability is what power exploits. The question Nigerians asked was not whether the request met technical standards. It was why a lawful request triggered such an aggressive procedural response. Because nothing here threatened the court. Nothing here undermined the law. Nothing here demanded collapse. Unless the objective was never to consider the request at all. Which brings us to the moment when unfamiliar names enter familiar tragedies. His name was Dimu Asen. To most Nigerians, it meant nothing. And that is precisely the problem. A lawyer assigned by the Legal Aid Council of Nigeria, stepping into a politically sensitive matter at its most delicate point. No long history with the case. No visible continuity. No public explanation. Unknown lawyers appear when power wants silence. In high-stakes cases, continuity is protection. It shields strategy. It buffers pressure. It resists sudden shocks. Replacing counsel at a sensitive procedural junction does the opposite. It isolates. A new lawyer, unfamiliar with the battlefield, is more exposed to administrative pressure, to psychological weight, to risks that experienced counsel know how to navigate. And then there was the language shift. Mahazano. Nnamdi Kanu names used selectively, interchangeably, strategically. As if identity itself could be blurred through repetition. This is not accidental. Names carry power. And when systems want to diminish resonance, they dilute recognition. The public began to ask the question no official wanted to address. Why now? Why this lawyer? Why this moment? Because systems that operate in good faith do not gamble with representation at critical stages. They stabilize. They protect continuity. Unless instability is the point. And then came the moment that confirmed everyone's fear. It happened in the courtroom. Not before. Not after. Right there. Without warning, without prior adjournment request, without the usual professional choreography, the lawyer asked to withdraw. Lawyers don't flee unless something is wrong. The judge asked the obvious question, why withdraw from a case to which you were officially assigned by the legal aid counsel? The answer was procedural. Clean. Technical. Safe. But safety is not innocence. If this were a simple professional disagreement, protocol exists. Lawyers request adjournments. They consult. They withdraw after procedural steps are completed. They do not collapse a live motion. Invoking Order 50 Rule 1 at that exact moment was not neutral. It was surgical. It severed the case from substance and reduced it to error. In one move, the court was no longer considering safety, detention conditions, or rights. It was considering paperwork. And paperwork always wins. This is how justice is avoided without being denied. No ruling on merits. No debate on facts. Just a procedural dead end. Law does not break here. It hides. And when lawyers retreat mid-hearing, Nigerians are right to ask, what made staying more dangerous than leaving? The reasons given sounded professional. Lack of affidavits. Client insisting on controlling submissions. Ethical discomfort. All plausible. None sufficient. Because clients asserting control is not rare. Lawyers manage it every day. They negotiate scope. They document disagreement. They continue representation until stability is restored. What they do not do is abandon a live procedural motion unless the risk outweighs the duty. So Nigerians ask the only question that matters, who benefits? Who benefited from the motion never being heard? Who benefited from silence replacing argument? Who benefited from time being wasted? Ask yourself who benefits from silence. The law did not. The public did not. The detainee did not. But systems benefit from delay. From confusion. From procedural fog that keeps truth at a distance. This is where pressure becomes plausible. Not proven. Plausible. Pressure does not need to leave fingerprints. It only needs to change behavior. And behavior changed. Which is why this was not just a withdrawal. It was a signal. And then came the silence. No statement from the Legal Aid Council. No reassurance from the National Judicial Council. No clarification. No concern. No accountability. When NJC stays silent, injustice speaks. Silence is not absence. It is position. In systems that respect credibility, silence after irregularity is impossible. Explanation is mandatory. Transparency is urgent. But in Nigeria, silence has been normalized as governance. The NJC's silence did not prove wrongdoing. But it amplified suspicion. Because institutions that believe in their own integrity do not hide when questions arise. They confront them. By saying nothing, the system spoke volumes. It told Nigerians that procedure mattered more than perception. That order mattered more than trust. And trust, once broken, does not heal through silence. It rots. This is not just about Nnamdi Kanu. This is about every Nigerian who has stood powerless while procedure erased their voice. Every citizen who watched a lawful request die quietly. Every family told to be patient while files disappeared into time. Today it's Kanu, tomorrow it's you. That is the fear hidden beneath the outrage. Because if procedure can neutralize one high-profile case this easily, imagine what it does to ordinary people with no audience. This is why Nigerians are not just angry. They are wounded. They recognize themselves in this moment. The helplessness. The confusion. The realization that the system does not bend toward justice, it bends toward comfort. And once people see that, faith collapses. Not faith in law. Faith in fairness. Faith without resistance is surrender. Scripture reminds us that justice is not optional. That silence in the face of injustice is participation. This moment demands attention. Not violence. Not chaos. Attention. Write. Speak. Question. Remember. Do not let this become another case buried under procedure. Because justice that cannot survive scrutiny is not justice. It is power wearing a robe. If this message resonates, do not scroll past it. Subscribe. Like. Share. Ask the hard questions in the comments. Because history is watching. And history will remember who stayed silent and who refused to look away. This is where the law stops speaking and conscience begins. Because when a justice system answers legitimate questions with procedure instead of truth, it is no longer asking for respect. It is asking for submission. And submission is not what law was created for. For decades, Nigerians have been trained to lower their expectations. To accept delay as normal. To accept silence as professionalism. To accept procedural collapse as fate. But fate is not neutral. Fate is often designed by those who benefit from time. Every time a case disappears into paperwork, the public loses something invisible but essential: belief. Belief that the system sees them. Belief that the law protects the vulnerable as fiercely as it shields the powerful. Belief that patience is rewarded rather than exploited. This is how societies hollow out. Not with tanks. Not with coups. But with routines that quietly teach people to stop expecting justice. The Mahazano Nnamdi Kanu hearing did not end with a ruling. It ended with a lesson. A lesson that procedure can be used as a wall, not a window. A lesson that accountability can be delayed without being denied. A lesson that silence can be louder than any verdict. And once people learn that lesson, they never unlearn it. That is why this moment matters far beyond one case. It is about whether institutions still feel accountable to the people they govern, or only to themselves. Scripture warns us that when leaders judge for reward, when justice is bent by convenience, the foundations shake. Not because God is dramatic, but because trust is structural. Remove it, and everything built on top begins to crack. Nigeria is standing on that crack. You can feel it in conversations that turn bitter. In debates that no longer seek understanding, only confirmation. In citizens who no longer ask what the law says, but who the law serves. This is not radicalization. It is disillusionment. And disillusionment is dangerous because it makes anything seem reasonable. That is why attention is the last peaceful weapon ordinary people still have. Attention forces explanation. Attention demands accountability. Attention denies systems the comfort of forgetfulness. When attention fades, invisible money keeps circulating. Delay keeps paying dividends. Silence keeps winning. But when attention stays, when questions are asked repeatedly, publicly, relentlessly, power becomes uncomfortable. And discomfort is where reform begins. This is not about choosing sides in a political battle. It is about choosing whether justice should be reachable or ritualistic. If you believe the law should protect human dignity, then procedural sabotage should disturb you, even if you disagree with the person at the center of the case. Because the moment you justify injustice against someone you dislike, you authorize it against yourself. Today it is Mahazano. Tomorrow it will be a name you recognize. Or a name you love. That is not fear-mongering. That is how precedent works. The system learns from what it is allowed to do. If it learns that silence is acceptable, it will be silent again. If it learns that delay has no cost, it will delay again. If it learns that procedure can erase substance, it will repeat the trick. And each repetition makes the next one easier. This is why faith matters here, not as ritual, but as moral insistence. Faith that justice is not just a legal outcome, but a moral obligation. Faith that systems must answer to people, not the other way around. Faith that truth is not a favor to be granted, but a duty to be fulfilled. Faith without resistance is surrender. Resistance without violence is responsibility. You do not need to burn anything to resist. You need to refuse amnesia. You need to remember dates, names, patterns. You need to ask why silence follows irregularity. You need to insist that explanation is not an attack, it is accountability. If you are watching this from the diaspora, understand this: distance does not neutralize responsibility. Silence abroad still strengthens silence at home. Your voice travels. Your questions travel. Your attention travels. If you are watching from inside Nigeria, understand this: the feeling that you are alone is part of the design. It keeps people quiet. It keeps outrage fragmented. But millions are watching the same patterns, asking the same questions, feeling the same unease. That shared unease is not weakness. It is the beginning of solidarity. Justice systems do not reform because they are polite. They reform because sustained attention makes stagnation more expensive than change. So do not let this moment dissolve into another headline. Do not let procedure bury substance. Do not let silence be mistaken for resolution. Write about it. Talk about it. Ask about it again next week. And the week after. Because power can wait. The public must not forget. If you believe justice should mean more than paperwork, stay engaged. Subscribe. Share this with someone who still believes nothing can change. Leave a comment asking the question officials refuse to answer. Not out of hatred. Out of responsibility. Because justice that cannot survive scrutiny is not justice. And a nation that forgets this lesson pays for it slowly, quietly, and at a terrible price. At some point, every society reaches a quiet crossroads. Not the kind announced on television. Not the kind marked by protests or elections. But the kind that happens internally, when